Students, in this video, I am going to discuss with regard to the problem solving with regard to the partnership firm. As you know that the dissolution of the partnership firm, there are two methods are there. That means there are two types of dissolution of firm is there. One is by the dissolution without the intervention of the court or dissolution without the order of the court. Another is dissolution by the court order. So these aspects we can see under the section 44. So here with regard to the dissolution by the court we can see under section 44. With regard to the dissolution without the order of court we can see under from section 40 to 43. That is dissolution without the order of the court we can see under section 40 of Indian Partnership Act till section 43. And with regard to the dissolution by the court order, so there we can see that aspect under section 44. So with regard to the problem solving questions in exams, the questions may be given that how far you understood the concept of law. So this is also one of the way of testing your legal knowledge. So here I have in earlier video I have done a problem solving with regard to the misconduct. That means under the dissolution by the court order there are 7 instances will be there. So under which the court can order for the dissolution of the firm, that is insanity and permanent incapacity, misconduct, continuous breach of trust, transfer of interest, continuous losses, and the just and the equitable ground. So these are all the 7 grounds under which the court can ask for the dissolution of the partnership firm. So today let us see this aspect. Today I will not follow FIRAC method. I will follow only ILAC method. Here I am not going to do the facts. Here you can follow any method. This issue rule analysis conclusion method also you can follow. But here what is the intention that all the legal content should be there with regard to the problem solving questions. So this is the question. P, Q and R enter into a partnership agreement to fly motor buses. That means what happens? There is a partnership agreement between 3 persons to fly the motor buses on certain routes for a period of 20 years. They got the permission. So they formed the partnership firm to run the buses in a particular route for a period of 20 years. So here this is for a particular period. So the business was run for 4 years. It was found that during the 4 years the business resulted in a loss each year. So the business was run for 4 years. It was found that during the 4 years the business resulted in a loss each year. P, however, insists on the business being continued for the remaining period. Can P so insist if he can state the way open to Q and R who are not willing to continue the business? Here one partner wants to he wants to end the business because there is continuous loss is there. Even though it is they have got the permission, everything is there. But as you know, according to section 4, why the partners they will come together, they will make the agreement. So in order to make the profit, that is the main intention. So this is the question has been given. So here what we have to write? We have to write what you call the issue. We have to write the provision of law, and we have to write the analysis. Then we have to write the conclusion. Whether a partner can ask for a dissolution of partnership firm on the ground of continuous losses. Even though you can add here also. Even though it is a partnership for 20 years. So even the partnership may be the agreement may be for even though the partnership is for a certain period. Partnership is for certain period. So the question is that whether a person can whether the partnership can be asked for the dissolution of the whether a partnership whether a single partner or the any other partners, they can ask for the dissolution of the partnership. So whether if there is any continuous loss is there, whether they can ask for the dissolution of the partnership. That is the issue, that is the question in law. Here that is the issue. So this aspect is we have to discuss here. This is the issue. So here, as you know, that under Indian Partnership Act, without the intervention of the court, that is from section 40 to 43 is there. Under section 44, there are so many instances are there. So under section 44F, if there is any continuous loss is there, any one of the partners or partners, they can ask for the dissolution of the partnership firm. The applying case law is the Jennings versus Badley. You can refer this case law also. The analysis is that you can write all these things as per section 39. A dissolution of partnership between all the partners of the firm is called a dissolution of the firm. So here these things are there, and we can write the methods of dissolution of firm. That is dissolution without the order of the court, dissolution by the court order. Here relevant aspect is continuous losses. So under section 44F, it has been given, when a business of the firm is running at a loss for a continuous period, then the firm may be dissolved by the court order. Generally, the object of the partnership is to earn profits. But when it becomes impossible to make profit, the firm can be dissolved by the court order. So this is the provision of law we can see. So here we have come to know the issue. What is the issue? So here the issue that when there is continuous losses, even though it is for the partnership is for a certain period, what should be done? So they can ask for the dissolution of the partnership firm. It has been given under section 44F. So there is applicable case law is Jennings versus Badley. So in the analysis, in the conclusion part, we can write all these things. According to section 44, business at loss, the court may dissolve the firm at the suit of the partner. This is the conclusion. Here, perpetual loss, that is under section 44F, the aspect has been given that perpetual loss. So here under section 44, it has been said with regard to perpetual loss. At the suit of a partner, the court may dissolve a firm on the ground that the business of the firm cannot be carried on. So to save at a loss. So according to the definition of partnership in section 4, the chief objective of partnership is to acquire profits. That means here what I want to say, that the chief objective of the partnership firm itself to acquire profits, to make profits. That's why they are doing business. If the circumstances are such that this chief objective, that is the main objective, cannot be attained, and the business of the firm cannot be carried on save at a loss, so firm may be dissolved by the court on this ground. So this can be it is appropriate to close the business. So every partnership firm is established to attain a particular objective, and if the circumstances are such that it's not possible to attain the objective, the remedy in such cases is to dissolve the firm. So we can discuss one case examples also. For example, in a case of partnership firm was established for the exploitation of a mica from mines. So this is the example. One of the partners filed a suit for the dissolution of the firm on the ground that the firm is suffering from losses continuously. So other partners opposed the suit on the ground that the partnership was for a fixed period. So as we have seen in our the problem, so here also the partnership is for a fixed period, that is 20 years. Here there is the buses has run only for 4 years. So it was found that during 4 years the business resulted in loss each year. So here P, however, insists on the business being continued for the remaining period. That means P, he insists for the continuation of the business. Probably he may think that in future there may be profits may come. So can P so insist if he can state the way to open Q and R who are not willing to continue the business. So the other partners Q and R, they do not want to continue the business because there is a loss for the continuous period of 4 years. Here even though the partnership is for the period of 20 years, so it is appropriate to close the business. Same thing we can see in this example also. Here also they were carrying on the business of mica. So here what happened? Here also there is a partnership established for the exploitation of mica from the mines. So one of the partners filed a suit for the dissolution of the firm on the ground that the firm is suffering losses continuously. Other partners opposed the suit on the ground that the partnership was for a fixed period and that the plaintiff has no valid reason to dissolve the firm before the expiry of the period. So the court held that section 44F will apply in this case and that the plaintiff is entitled to sue for dissolution and accounts. So that is the thing. So what should be the conclusion is that the other partners they can ask for the dissolution of the firm. So that means the option the answer for the instant problem is that other partners that is Q and R ask for the dissolution of the firm. By filing a suit in the court of law. By filing a suit in the court of law. So this is the answer for this the instant problem. So certain times the question may be very much simple, but what happens? Certain times there will be some technicality will be there, but we have to know what is the technicality. So when you appreciate the question of law, and if there is no question of law is there, then we have to go for the question of fact. So in this way, if you know the law, you could be able to answer any problem which may be given in the examination. So this is with regard to the problem with regard to the dissolution of a partnership firm concerning to the section 44F with regard to the continuous losses.